I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay.
that's licensed to practice
Okay.
to do this.
Right out of the gate, Judge Simpson is done playing procedural ping pong. This is not a warm-up. This is a judge signaling that patience has officially expired, and that matters. Because when a court says it's not going to continue to lay this matter out, that's judicial code for delays are over, compliance is expected, and consequences are coming. What we're watching unfold is a procedural breakdown, not a dramatic cross-examination, not a fiery closing argument, but something arguably more dangerous. Repeated failure to follow basic court rules. The judge already told this party what was wrong in a previous hearing. He struck the pleadings, he gave instructions, and now we're back with the same issue. And here's the tension. When a litigant says, "What am I doing wrong?" after the court already explained it, that's a flashing red light. Is this confusion? Is it strategy? Or is it defiance? Because in court, misunderstanding can be corrected, but repeating the same procedural error after clear instructions, that's when credibility starts to crack. And notice the subtle escalation. Maybe you need to get an attorney. That's not just advice. That's a warning. When a judge suggests you may be in over your head, it's because the procedural mistakes are no longer harmless. This case isn't just about possession or paperwork. It's about whether the court believes someone is trying to navigate the system or manipulate it. Stay locked in. Because the caption issue, that's about to become the central battleground.
J Group Holdings versus Azar Stafffield. They didn't say.
Good afternoon, Your Honor. Plaintiff Anthony Momena appearing on behalf of Plaintiff Charles.
Good afternoon, Your Honor. Azar Stafford.
Your interpretation in this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case, because she had changed the caption. They were to be refiled and served.
This is a critical legal moment. When a judge strikes pleadings, it's as if they never existed. They're erased from the court's consideration. Why? Because court documents must follow strict formatting and caption rules. The caption, that top section listing parties and case number, isn't cosmetic. It determines jurisdiction, party identity, and legal standing. Changing a caption improperly can create confusion about who is actually part of the lawsuit, and in some situations, it can even affect the court's authority over the parties involved. That's why Judge Simpson is laser-focused on it. Now here's the issue. The judge gave clear instructions. Refile with the correct caption. Serve opposing counsel. Simple procedural compliance. The whole case pauses until that's done properly. But now we have conflicting statements. She says she served it. The attorney says he never received it. The court file doesn't reflect a proper refile. In litigation, proof of service is everything. Without it, it's just a claim. And here's the question for you. If you were in her position, representing yourself, would you double-check every single procedural detail before filing again? Or would you assume the court would figure it out? Because right now, the judge is seeing a pattern, and patterns influence rulings.
They were not.
Was that done?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court, we did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
We'll try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we
My sole question to you is,
okay.
did you do that?
Yes, Your Honor.
Thank you. Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd, I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it, but she's telling me she didn't. That was,
Not by me, Your Honor.
yes, okay, I see that. But that was not the original. All right,
I have not seen that.
service on here, I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
Then he needs to properly join the case. I don't. You did it again. The caption you just changed.
This is the moment frustration becomes visible. You did it again. That's not neutral. That's judicial exasperation. It means the court sees repetition, not progress. When you represent yourself, courts give some flexibility, but that flexibility disappears when instructions are ignored more than once. The judge isn't debating the legal merits here. He's evaluating compliance. And here's what makes this dramatic. She insists she followed the rules. The judge insists she didn't. That's a credibility showdown. Notice how the judge refuses to even look at the document being offered. That's significant. He's drawing a line. He's saying, we are not relitigating the same procedural mistake. From a legal standpoint, improperly filed documents can stall a case indefinitely. And if one side believes the other is using that to buy time, that's when the tone shifts from procedural correction to potential strategic delay. Let me ask you this. Do you think this is genuine confusion about court rules? Or do you think this is someone trying to keep the clock running? Because possession cases move quickly, and every delay affects someone's property rights.
May I speak, Your Honor?
Yeah, go ahead.
Okay.
We did the same thing we did the last time.
And may I show this to your,
No,
this,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
God. You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
This is a textbook legal misstep. Only the plaintiff can voluntarily dismiss their own claim under that procedural mechanism. A defendant, even a counterplaintiff, cannot dismiss the plaintiff's case unilaterally. What the judge is clarifying here is standing and procedural authority. Even if she filed a counterclaim, that gives her limited power over her own claim, not his. So when she files a notice of dismissal by plaintiff, the court sees a fundamental misunderstanding of roles. Or worse, an attempt to shortcut the process. And here's where it becomes serious. Filing incorrect dismissal paperwork doesn't just get ignored. It signals to the court that procedural compliance is unstable. Ask yourself, if you were the opposing attorney watching this unfold, would you see this as confusion or as evidence that the other side is trying to derail the timeline? Because Judge Simpson is drawing a bright line. You can't dismiss his claim, period. And when a judge refuses to accept filings until the caption is correct, that's a procedural lockout.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to...
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I am not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
This is a pivotal emotional moment. The defendant asks what she's doing wrong, again. But notice the judge's response. I have already told you. At this point, it's no longer about explanation. It's about repetition. Judges expect litigants to listen, adapt, and comply. When that doesn't happen, patience erodes. And then comes the strongest procedural suggestion yet. Maybe you need to get an attorney. That's not sarcasm. That's strategic advice. Because representing yourself in property litigation, especially with federal filings and counterclaims, is complex. One misfiled document can undo weeks of strategy. But here's the human layer. She mentions a funeral, a family loss, emotional strain, and the judge expresses condolences, but does not delay further. Why? Because courts balance sympathy with structure. The personal hardship does not suspend procedural rules. Here's the engagement question. Should judges give more flexibility when someone is self-represented in dealing with personal hardship? Or is consistency more important than compassion in court? Because today, structure wins.
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay.
that's licensed to practice
Okay.
to do this.
Okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right.
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Good.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises there was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak. And we need.
What way?
There's significant runoff and sediment runoff. The backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit. She's doing everything possible to delay our occupancy, and I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Now the narrative shifts. The attorney is framing this as strategic delay, not confusion. He's listing damages, runoff issues, alleged ordinance violations, unpaid rent, jury fees. He's building prejudice. That's key. Courts respond when one side demonstrates ongoing harm. And notice his strategic move. He suggests issuing judgment for possession now, even if she plans to appeal. That's aggressive but procedural. It moves the clock forward. The attorney is painting a picture. Occupancy without payment, property damage, procedural chaos, federal filings duplicating state claims. And here's the tension. Judge Simpson says she knows well what she's doing to buy time. That's powerful. When a judge suggests awareness of strategy, credibility shifts dramatically. Question for you. If someone files federal suits mirroring state claims and repeatedly misfiles pleadings, does that look like defense strategy or obstruction? Because in possession disputes, time equals leverage.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started. If at all the court would go along with us, let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
Yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I'm going to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And what by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay,
Yeah.
I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy, okay? This loan shark and his attorney are trying to,
Are you almost done?
yes,
Good.
to take us out of our home.
Now we see her core defense, the lien issue. She argues that because a lien was placed on the property during the redemption period, she cannot secure financing to repurchase the home. That's not a trivial claim. Liens can absolutely complicate mortgage approval. But here's the legal distinction. The dispute may belong in a separate action. It doesn't automatically halt a possession case unless properly raised and supported procedurally. And notice something important. When she begins accusing opposing counsel of violations, the judge immediately redirects her. You need to talk to me. That's courtroom discipline. Arguments go through the bench, not across the aisle. She frames the plaintiff as predatory, loan shark. But emotional language doesn't replace procedural compliance. So here's the key issue. Is the lien a legitimate barrier to performance under the agreement? Or is it being raised to offset possession consequences? Because without clean pleadings and proper service, even strong arguments lose traction.
And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, you can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not going to yell when you're in here. You're not going to whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
You too, sir.
I don't want to call anymore. I'm done. I'm so done. Yeah, here, you take it.
Judge Simpson closes this hearing with clarity. No ambiguity. Fix the pleadings, follow the rules, or bring counsel. This wasn't a ruling on possession today. It was a procedural ultimatum. Here's the broader picture. The defendant's filings were struck for incorrect captioning. She attempted to file a dismissal she was not authorized to submit. The plaintiff alleges ongoing property damage and unpaid obligations. There's a parallel federal case complicating the landscape. The court suspects strategic delay. The next hearing becomes pivotal. If the pleadings are still defective, the judge's patience may convert into enforcement. And that final courtroom moment, where the judge addresses whispering and tone, shows something deeper. Control of the courtroom matters as much as control of the paperwork. Right. Procedure is power in litigation. Ignore it, and your argument collapses before it's even heard. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.